Hello friends, it's my pleasure to give you a presentation on labor law pertaining to that of the Provident Fund. Even if it is enacted in the year 1952, a benevolent enactment for the welfare of the labor class in our country, this enactment seeks to achieve the social sector security for this labor workforce of our country. It seeks to achieve security and safety and prevent any exploitation of the workers in an industrialized economy. And accordingly, this enactment was enacted with a requirement of contributions from the employer and employee towards the Provident Fund created by the Employees Provident Fund Organization constituted by the central government under the EPF Act of 1952. The thrust, therefore, is for the welfare of the workers. But the levy is imposed qua the employment. So this is a levy, a liability created by a voluntary action of every manufacturing establishments. And these establishments, when they will employ more than 20 number of workers, they will cover under the Act. And then the establishment need to be registered, and accordingly the liability towards the employer contribution and the employee contributions would have to be deposited with the EPF organization by every employer. That's the broader scheme of this particular statute, in order to achieve the social security intended for this working class workers of our country. But as we all know, our workers in the industrial sector are distributed amongst organized and unorganized sector, and therefore implementation of this particular statute has its own pitfalls because of this anomaly in the system, because not all are covered under the statute. Not all establishments, not all workers are covered under this. The requirement is 20 and above or 10 and above. And when this requirement is there, and that means there is an exemption is there, then you cannot find an uniform application of the statute. These are the teething problem of the statute. But one thing is a very clear till date, 1952 till 2016, 28th of January, where I assisted the court, one Odisha High Court, to get one landmark judgment on the responsibility and the duty of the EPF organization, A, and B, the liability that would accrue under the statutes in what circumstances. These are the two broader points, have never been defined by the courts with a clarity till date, till this judgment came on 28th of January 2016 in the case of Utkal Ropes versus EPF Appellate Tribunal. The court interpreted this section 6, the incident, the enabling, the incidence of liability provision, read with section 1 and 5, besides the definitions of employer and employee, to hold that the liability under the EPF Act is accrued on an act of voluntary action undertaken by the establishment. In other words, when an employer, that is the establishment, employs more than 10 or 20 above, as the case may be, in that event, the liability will accrue from the date and time on which the number of employees employed by the employer increases 20. The triggering point is 20. So therefore, the choice lies with me, how many number of workers I will engage. The moment it crosses 20, the statute will fasten and the liability will accrue. And it will remain in suspended animation, notwithstanding the demand made by the EPF organization at any point in time. But the testing point is, the critical point for the test of applicability of the liability, the testing point is my voluntary action to a point 20 and above. And when the establishment demands any liability against me for the first time, treating me as being coverable under the statutes pursuant to section 1(5) of the Act of 1952, it is the responsibility of the department, which the court held, is the cardinal point, that this responsibility lies on the establishment to demonstrate that this triggering point has come into operation and on such date, which means it has to say with a specific means that such persons have been employed, and from such and such date they have been employed, and there is an employer and employee relationship exists, and he has to demonstrate from my own record. And it cannot be allowed for the organization, the EPF organization, to shift the onus on me to say that no, I have not employed 20 and above. It's for them to demonstrate that I have employed. And that is where this particular judgment is a landmark. And for the first time, this particular judgment has dealt with and decided on two aspects. I am sure it will pave the way the EPF Act has been administered till now and has been understood by the operators till date. And according to me, on these two significant issues, the most critical issues, it has brought the entire regulatory regime on unifocal, unipoint means, and that will be a game changer for all of us in futures, how it is to be administered and regulated. I'm sure it will help you in guiding yourself, in advising, in administering, in regulating the way this particular statute has come in the way in the last 70 years. Thank you so much.